Justice Najfi, if I may come to you next. Looking at some of these examples, and even from Pakistan's history as well, would you be able to illuminate your perspectives on if we're looking at bail reform, or even if we're looking at legal reform, as Abid Saab was talking about in Justice Nasra, where we reduce mandatory pretrial detention, or we reduce criminal penalties? Do you think that that would have an impact on prison crowding or overcrowding, all of that? So, would you like to speak from there or from here?
Thank you very much for giving me an opportunity to talk about the reforms in the criminal justice system so as to reduce the incarceration in the jails of different prisoners. Uh, it's an admitted position that in our jails there's overcrowding of the prisoners. Under trial prisoners are about 65% occupancy in jail, and the UTPs are either of minor offences or offences falling in the prohibitory clause of Section 497 CRPC, more than 7 years imprisonment, or maybe of life imprisonment. As our distinguished participant was mentioning, that it's correct that in our jails, many of the under trial prisoners are charged of narcotics, possessing narcotics of different volume. We have also prisoners in the jail who are facing charges of offences against property. These overcrowding in the prisons can be reduced by adopting certain measures. Number one, we should encourage a system in which the trial should be concluded expeditiously. And for that, we should employ the modern techniques of digitization. The modern IT equipment should be applied to ascertain the minimum benchmark which is required for the disposal of the cases. Number two, we should sensitize our judges that liberty of an individual is very precious, and our bail granting parameters, which are fluctuating from case to case basis, should be applied according to the given situation. There are instances in which the offences, the police unfortunately involve certain prisoners, certain citizens of our society, owing to some feuds or owing to some animosity. In that situation, we can understand the judge should
police officer is, prosecution is there, so all the stakeholders are there. They can think over, okay, how the prison population can be reduced, especially the under trial prisoners. And one more important thing that is related to the District Criminal Justice Committee, that is purely related to the district and session judge. District and session judge pay visit to the district jail of his or her jurisdiction, and he releases the prisoner on the involved in petty crime. I collected the data of 2023. Total about 10,000 prisoners were released by the visits of the district and session judges, and majority of them, 99%, are involved in Section 9A of CNSA.
So, my experience working on the criminal side is that the most of the cases pouring into our judicial system are for the grant of bails. As Madam Nasra has pointed out, very rightly so, that in our jail we have seen so many prisoners who should not have been sent to the jail at the first instance. Their cases are false, they are politically motivated, they are
Prison Act 8.
based on vengeance, animosity, or feud, and sometime the offences are of such a nature that the police is in habit of involving just to show their efficiency. So in these like situation, I think the law of bail is very much available to a judge, which he should exercise whenever so demanded. Well, answer to your question is this: my paper is already there, but I will not have time to see that. But perhaps answer to any question, I will dial it upon. Thank you.